So I'm going to be starting us off. My name is Melissa Goemann. I'm the Senior Policy Counsel at the National Juvenile Justice Network. We also have two wonderful presenters. I encourage you to look at their full bios, which is on the registration page. So following me will be Elizabeth or Betsy Clarke, and she is the president and founder of the Juvenile Justice Initiative, which is a member of NJJN. Betsy has successfully advocated for many reforms in Illinois throughout her years as president and founder of JJI, and she was also a founding member of the National Juvenile Justice Network. And then we have Lambert, who is a restorative justice facilitator, and he's with the Office of the Attorney General here in Washington, D.C. And in his role, he's successfully diverted many young people from the deep end of the system. And he also began his work in D.C. public schools, where he was trained in restorative justice. Okay. 1 second. All right. For those of you who aren't as familiar with National Juvenile Justice Network, we lead a national movement of state-based juvenile justice coalitions and organizations, as well as we have a very growing cadre of alumni of our Youth Justice Leadership Institute. NJJN was founded in 2005, and we're a member-led organization that fights for change locally and nationally. We seek to shrink our youth justice systems and make what remains fair and effective, and make it a system that treats youth and families with dignity and humanity. And just a little about a growing program we have, which is our NJJN Ally program, and these are either individuals or organizations that want to be part of the movement, might not be able to be a member, but can join as an ally and continue to help us improve outcomes for youth. And I have at the bottom the website, which you can go on to find out more about becoming an ally. So I'm going to start us off with a little information about New Zealand's youth justice transformation. And we recently published a paper on this, and you can find that in the resource section for the webinar, as well as several other publications on restorative justice. I believe that Betsy had provided to us as well. So the reason we're talking about New Zealand is twofold. One, they've made great use of restorative justice throughout their youth justice system, but also they, prior to passing this big transformative law that they passed in 1989, they had many problems that were very similar to the problems we're facing in the U.S. So as you can see on the screen, they had high and growing youth incarceration rates. They also had a problem with overrepresentation of their population of Native youth, in this case the Maori youth, compared to the white or European colonizer population. They were using a lot of arrests of young people, processing a lot of young people in the court system instead of being diverted. And they were using very alienating court processes. Young people and their families found it difficult to engage with. So in 1989, as a result of a lot of agitation by the Maori people, who were very concerned with this high rate of incarceration of young people, as well as general public's dissatisfaction with the justice system, they passed the Arenga Tamariki Act, also called the Children's and Young People's Wellbeing Act. And the key components I'll go through, but I will point out that at the time, restorative justice was not a widely known philosophy or process, so it's not actually named that in the original act, though it's clear that they are using restorative practices. So they started by trying to not just use restorative practices, but really reduce the number of kids in the system, reduce the front end. So they imposed mandatory limits on arrest by the police, and that has really driven down the arrest numbers. Another key component is separating care and protection from justice issues. So they actually have kids 10 to 13 go to a different court. They go to family court where they deal with offending issues as well as things like abuse and neglect. And then youth that are 14 to 16, soon to be raised to 17, go to the youth court to deal with any offending issues. Another key component is the restorative practices. So young people, if there are minor offenses, these are diverted out of the system altogether. And what they use their restorative practices for are the more serious offenses. And these young people, before going to court, will go to family group conferencing, so that the court processing actually becomes a last resort for the system instead of kind of a go-to model, which we often have in this country. And this allows for much deeper family engagement. So as a result of New Zealand's change and transformation with their new law, they were able to greatly reduce the number of arrests and court processing. As you'll see, they have arrested only about 12% of all cases of youth offending, and the number of kids charged declined from 6,000 to 1884 in 2017. They also, this was not accompanied by any increase in youth crime, and in fact, their youth crime has recently declined by about 33%. They also have studied victim satisfaction with the family group conferencing, which is, you can see, at least from this one study, quite high. But the sticking point, as we often have in this country, is that Maori overrepresentation in the justice system has increased. So while the total numbers of all youth in the system, including Maori, has declined, the number of white youth in the system has declined at a much faster rate than the Maori youth. And of course, we see this all the time in this country in terms of white youth and youth of color. So you can see the stats there are showing pretty high rates for Maori overrepresentation. So the issue is that Maori agitated for the change, but then they were not adequately included in designing and implementing the changes. And so this is a strong factor we see in ongoing overrepresentation of Maori, and I would say in our populations of the color in this country as well. We see the same dynamic for marginalized populations. So one question we want to ask is how we disrupt this dominant power structure. And I'm not going to go through everything on this screen, but we've developed 4 questions to assess your work or campaign through an anti-racist lens, and we're happy to provide you with further information on this, so just contact me if you would like that. So briefly, we have 3 main lessons we learned from the New Zealand system. One is that those most harmed by the system must be integral to the design of its transformation. And as I discussed, that that didn't happen. But to their credit, New Zealand passed some significant amendments in 2017, and one of the goals were to lead to increased Maori control over the youth justice process. So they did things like require their chief executive to invite proposals and set targets to improve the outcome of justice-involved Maori youth, to delegate functions under the Act to Maori organizations, and to support cultural competency of justice system stakeholders. So all lessons that we might use as well. Secondly, it's very important to shrink the system drastically. So it's really not enough to just implement restorative justice practices, but you really need to shrink the front door of who is getting in the system, as they did by limiting arrests and making much greater use of diversion. And finally, you want to orient the formal system that's left around restorative justice practices. And New Zealand did this through their use of family group conferences. They used these at a number of different points actually in the system. As I said, police cannot arrest in a lot of cases. If they want to charge, they actually have to bring the young person to a pre-charge family group conference that decides if the young person should be charged. And then again, a trial, if a young person denies the charges, they would go to a family group conference, and that would involve the young person, anyone who plays an important role in their life, experts such as teachers or health workers, and the victim is invited as well. And the point of the conference is for the participants to discuss the offense, the impact it's had on the victim and the young person and their family, and to collaboratively work on a plan to help the young person not only to have accountability, but to deal with any issues that might have brought them to this point. And then that plan does have to be brought to the court, which generally is opposite in most cases. So I'm going to turn the screen over now to Betsy, and she's going to now discuss some of the lessons that they've learned in Illinois and what they've been working on.
And so hold on a second. Okay. Hello, everybody. I'm going to run through this pretty quickly. There'll be a copy of the PowerPoint up available after this webinar as well. We are an NJJN member, and we've been increasingly focused on restorative justice because it's been growing organically out of a number of communities, especially in Chicago. It is a big deal in the US and the world. You should know there were over 4,000 participants at a national RJ conference in California last year. It's been in effect in the juvenile justice system in Northern Ireland since 2003. So Northern Ireland for juvenile justice and restorative justice is really the premier spot that has implemented this and studied this. It's a complex notion, and it is a vision of justice that's based on participation, reparation rather than punishment. It's evolving. It is, you should think about this as the equivalent in the criminal justice system, juvenile justice system, of what's been happening for decades on the civil side with mediation, and it's growing out dissatisfaction with the lengthy, costly, and excessively punitive proceedings in our justice system. Now, it is a lot of different practices are named restorative justice. It is not the quasi-criminal proceedings like peer juries, proceedings that pressure people to make, to acknowledge guilt, proceedings that utilize punishment, proceedings that I just heard about a month ago downstate in Illinois that make accountability public, these shaming kinds of proceedings. It is justice that is restorative should have lower rates of repeat offending, better outcomes with reintegration, and higher levels of satisfaction. And it is inherently based on community involvement, which gets to some of what Melissa was talking about. Now, as New Zealand had problems, so we are going to as well in integrating restorative justice. And this is best highlighted, I think, by a quote from a youth diversion worker in Oakland, who said he participated in a restorative justice conference, a school fight. The youth who was Black was arrested and went through community conferencing. The youth who was white involved in the fight was not arrested. That's a real conflict. That's a systemic racial bias that we must highlight and that we must work to avoid. But and another reason why restorative justice has to be fully implemented from the very beginning. And it's going to work better with serious cases. I mean, research that we all have worked with over the decades shows that low-risk youth do better without intervention. That's key to keep in mind. Other countries that have used, like Northern Ireland, that have used restorative justice successfully are countries that have ratified the Convention on the Rights of the Child and have this rights-based approach to restorative justice because it's inherent in their justice system. So whether you're looking to Canada and the Youth Criminal Justice Act, federal legislation that implements restorative justice, or Northern Ireland or New Zealand, these are rights-based approaches. And what you need in a rights-based approach is to ensure that principles such as voluntary participation, confidentiality, proportionality, and neutrality of the mediator are guaranteed. Guaranteed. Let me go over those again. Voluntary participation, confidentiality, proportionality, and neutrality of the mediator. You should also make sure that you are collecting information on the implementation, that the facilitators are highly trained, qualified, trained facilitators, and that there's regular monitoring of restorative justice proceedings. So looking at confidentiality and proportionality of the agreements that come out of these proceedings, Illinois has sort of an ad hoc group of lawyers and judges in Illinois put together a proposed rule for a new Supreme Court rule guaranteeing that information shared in a restorative justice proceeding would be confidential. And this is based on language that's in the Northern Ireland law. It is also based on similar kinds of privileged acknowledgement of privileged information on the civil side in mediation. What's key here is that whenever you have a restorative justice practice, the fact that it has been convened along with the information that is shared within it must be viewed as privileged. And the person who can waive that privilege would be the person who is impacted by it. The other participants, their communications would have to remain privileged as well. Not subject to discovery or disclosure in any judicial or extrajudicial proceeding. Most of the restorative justice practices that we've had already in place here in Illinois have been based upon informal agreements for confidentiality. And that's one way to do this. We're trying to embed this principle of confidentiality statewide in all restorative justice practices. One other thing you should know is that in trying to define a restorative justice practice, the proposed rule just kicks it back to the judge if it is challenged to determine whether it's a restorative justice proceeding that would fall under this rule. The rule has been proposed to the Supreme Court. There's been a public hearing on it about a month ago, and we're waiting to see if this will be adopted or not. There is as well, as of last August, a restorative justice community court in the west side of Chicago, North Lawndale area, one of the most impacted areas of the city. It involves a really visionary juvenile court judge who traveled to Northern Ireland to see juvenile justice practices in Belfast and how they were operating, and used that as part of her model. Juvenile court judge, but emerging adults from age 18 up to age 26. Nonviolent felonies, cases that are selected by the prosecutor, and both parties must agree to participate in the court. Again, there must be voluntary participation. There's a community conference that develops a repair of harm agreement that is then presented to the court. The court approves the agreement and reviews the progress of the report, and if completed successfully, the participant's record is cleared. This is very much based on community ownership in both the design and the operation of the court. It is located in a conference room in a community provider office in North Lawndale. It is developed through leadership by a community defender office where the lawyers live in the community. It is developed in partnership with Restorative Justice Hub, a collaborative of neighborhood leaders and organizations. And the community's been a full partner in the design and development of the court, even doing door-to-door canvassing ahead of the opening of the court to make sure the community was aware of what was about to happen. It relies on the community to be completely in ownership and control of the peace circles, the circles that come up with the repair of harm agreements. So there is no participation in these circles with anybody from the court, the judge, the prosecutor, the defender, no participation whatsoever. So the system has to rely on the community to have the circle and come up with the repair of harm agreement. The goal of the court is system transformation, which is some of what Melissa talked about before with New Zealand. The court doesn't participate in the circle, but learns from the repair of harm agreement about the barriers facing young people in court. One of the things the judge has talked about is the high level of housing instability of the young people who are appearing in this court. Many repair of harm agreements also include a goal of job readiness. So there's an educational function there through these repair of harm agreements. But again, they must be proportionate to the underlying offense. So you don't want 2 years of repairing the harm, and they must be confidential as well. And there's been an informal agreement by the court to have everything confidential. This is what it looks like. I think this is a picture from the planning group developing the court, but I was down and watched the court about 6 weeks ago, and it is just sitting around the conference table. Everybody is on an even level. Everybody is introduced at the beginning. There's a good deal of respect. Observers sit around in chairs on the outside. Very different look and feel to the court. And as I say, there's an agreement with the prosecutor for full confidentiality. There's monitoring to make sure that the cases that are selected are cases that would have gone deeper in the adult system to avoid net widening. They're trained circle keepers. There's no system involvement in the circles. There's an evaluation underway. There's ongoing dialogue between the system and the community. I've been this kind of difficult tension here. The judge doing this court spoke to our board last Friday, and we asked, what's easier, being a judge in a restorative justice court or being a judge in a regular juvenile court? And she said, oh, hands down, much easier being a judge in a juvenile court. It doesn't involve, this has been very new territory, and everybody is feeling their way to figure out their appropriate role in this balance between system and community as they go ahead. I want to be clear that it is not my coming up with this idea of a rights-based approach. I want to give credit to Shannon Moore from Minnesota, who first put together the idea of a rights-based restorative practice and has an evaluation toolkit for that. And I want to thank you all for your attention today. Thank you.
Great. Thanks so much, Betsy. So I'm going to now change presenters to Alex. Again, Alex Lambert with the Office of Attorney General in Washington, D.C.
Good morning, everyone. Let me get this screen shifted around. Here we are. Okay, so good morning. My name is Alex Lambert. As was previously stated, I am a restorative justice facilitator here in the D.C. Office of Attorney General, and definitely excited to share with you all the program in which we have implemented. And just to get into it, it's really something new and innovative here in DC, and it's really shaping up to be, as far as we know, one of the few or only of its kind to operate within the prosecutor's office. And so let's get started. So these are some of the questions I really want to answer. In my experience, some questions that when we have shared about our program. So basically, who do we serve? How are our cases selected? What are the steps to having a conference? And what type of cases do we accept? And what are some of the outcomes that we've seen? So in 2016, our Attorney General, Clarke, really part of his campaign shared about the importance of helping our juveniles, but also bringing attention to our victims, right? And helping to really bridge a gap in how our justice system separates those two. So our young people are heavily involved in our criminal justice system, and also victims kind of suffer not being a part of the process of healing. Restorative justice was something that was launched at the end of 2016 as a part of a DOJ grant that was received for smart prosecution. Here we go. So the community that we serve, we operate out of the juvenile section of the prosecutor's office, but our victims vary. Our victims could be the juveniles, our victims could be elderly, it could be adults, male, female, white, black. It really spans. So it's not a particular community. We end up serving theoretically the entire community because interactions happen across many boundaries. Our current process right now is cases come in typically after a juvenile has already been charged. So a juvenile has already been arrested and charged with the crime, and at that point, the prosecutor or a victim may ask for an alternative. So a prosecutor may say, I see this case is a situation where these young people know each other. I think this would be better served if they sit down and talk about it. Or I see this is a first-time offense for this young person. I really don't want them to go deeper into the system, so let's try restorative justice. A part of the prosecutors becoming aware of what restorative justice is, we've done training with them. We also incorporate them when they are not directly related to a case. We will let them see certain portions of the process so they can see how we interact with victims, how we talk with respondents, how we take care of our cases. A lot of our prosecutors take their cases very seriously, and they want to know that we're going to treat them with the same sensitivity that they would. So inviting them in our process to let them see how we would handle a case that they're not directly related to helps them to build confidence and trust in our process. Secondly, victims. Victims at times, or we're using restorative language, harmed parties, people who have been harmed, they at times don't want to have the person that may have done something to them go deeper into the system. They really would rather have a conversation. We have a lot of adults who like, listen, I know this kid may have taken my phone or this kid might have broken into my car. I don't really want him to go to jail or anything really heavy. I just want to talk to him, let him know some things. And we've seen a lot of people request that as well. So that's typically how we will see a case come in. So the type of cases that we accept almost any case with the exception of a few. So sex crimes, gun offenses, homicides, intimate partner domestic violence. And there are practices of restorative justice that do those. We just at this time have not expanded into those areas. We really believe that when you're dealing with those type of offenses, especially sex crimes and intimate partner domestic violence, that you need to really have a specialized training and to make sure we're protecting everyone who's involved. And so we just have it expanded to that. We are ensure, just like Betsy said, that any case that we accept is a case that it would have normally went forward. So if you're not going to move forward, if a prosecutor's not going to move forward with a case, we do not accept it, to also prevent from net widening. And we always evaluate every case that's come before us to see if RJ can be used before we just blanketly reject the case or say, oh, this case doesn't work. So at times there may have been a case that would not have gone forward, but we because of legality, but we may see that there's an issue in the community that might need to be helped to be worked through, and so we might step in and still facilitate a circle for the community, but it's not connected to any type of agreement or consent decree. It's merely us trying to help the community to work through whatever conflict there may have arisen. So this is basically our steps to how we move forward in a case. So what will happen is we receive a case from a prosecutor, and we'll assign a facilitator to that case, and we make initial contact with the respondent. The reason why we would reach out to, in most cases, not all cases, in most cases we'll reach out to the respondent or defendant, because of course this process is voluntary, it is not mandatory, and we don't want to reach out to the victim or the harmed party and say, would you like, and they say yes, and then the person who may have caused the harm or accused of causing the harm says, no, I don't want to participate. So we start with the person who's involved in the case. So the defense attorney and the respondent and their parent, right, or a defendant who is an adult, we work with them and talk with them to basically find out if once they agree, then we talk to the other parties. Once we get everyone on the same page about explaining the process, then we move into really talking about doing our pre-conferencing. So getting into what happened, who is affected, and what needs to be done to make this right. In situations we find that people know each other, what we found to be very repetitive in this process is that people know each other, there tends to be a history. So although the person who may have a case or have a charge may have got this charge, there's typically some other interaction, especially with young people. So fights or, social media conflicts that spill over. And so in pre-conferencing really gives us the opportunity to find out what happened without looking at who was accused of what. Just tell me in your own words what happened. And once we get to that, that really gives us a picture of how to formulate the conversation. So our team moots every case to really just talk about what are some of the things we want to bring out in this conversation, what are some of the questions we think are important, and we really use each other to help us to formulate the conversation in the best way that's most beneficial for everyone involved, for not just the young person who's involved, not just for the harmed party, for the families, for any supporters that come. We want to make sure everyone is engaged. And once we move and we talk about it, then we have our conference. Our conference is really set up in certain phases, about 4 phases. We go basically over the semantics, we cover any type of disclosures. We do sign a confidentiality agreement with the respondent or defendant, let them know that this conversation is confidential. If the conference at any point breaks down, nothing that you say can be brought up against from the prosecutors from this office. As a part of our protocol, no one from the court is allowed to be a part of our conversation. So no defense attorneys, no prosecutors, no judges. No one is allowed to be a part of the conversation who's connected to the case. And we also are very, we share, but we're also very cautious about what we share, what comes out of the case. We honor confidentiality, the things that are said we don't talk about. So once the conference is over, we will typically send an email or correspond with the defense and the prosecutor, let them know very basic information. We had a successful conference. We came to an agreement, and it was they shook hands, they apologized, but we don't really get into the individual specifics of what transpired to honor, the components and philosophy and the foundation of restorative justice. A part of our conference, we also make sure that we do community building. We have a community conferencing model, but we have adapted some other pieces to really make it more holistic in how we approach families. And one of the things that we always ask, regardless of the case, is we ask the young person, their supporter, to share out something positive or great or something that you're proud of about this young person. And we find that asking those questions has sometimes brought tears to the young person's eyes, has allowed them to hear some things maybe they hadn't heard in a while because they've been in trouble. And we also ask that of the harmed party, of the other group. So if there's another young person or an adult, and their supporters, because it also begins to humanize everyone to each other, that we're more than just this one incident. So after our phases of our conference, what happened, who was affected, and what needs to happen to make this right, which is almost identical to what Betsy is talking about. Everything is consensus. So it's not someone coming in saying, I want this to happen, and the young person has no voice. Everything has to be agreed upon as a part of the foundation and principles of restorative justice. So when someone recommends something, like somebody might say, oh, well, I feel like community service is what needs to happen to make this right. And the young person will say, okay, I agree, and the person might say, well, we go all the way through. So when, where, how, if restitution has been involved at times, if they agree, then we orchestrate making sure that everything is taken care of and agreed upon in the agreement. Then we move to the last part, which is monitoring. So most times our monitoring will never go past 6 months. But most times it's been less than that. Unless there's some type of agreement that would take us out to 6 months, then most times it's how are they going to interact. So we check in, especially if there was some kind of physical conflict, we'll check in, after the conference, make sure everything's going well, making sure that everyone's honoring the agreement. And we found to be everyone has participated in our program and came to a successful agreement. We haven't had anyone to break our agreements. Now, our agreements are set up that if they were to fall through, that the case would then be diverted back. That's a part of the original agreement. So if the young person agrees to do restorative justice, they understand they have to complete the agreement, and that's how their case, the result is their case will be withdrawn, the charges will be withdrawn. But if they don't, then whatever process it was going to go through before, that's what it will go through. Most times I've yet to see that ever happen, to where a young person who participates in our program doesn't come in, complete their agreement, and go all the way through completion. So that's one of the things we're really excited about and happy about. I had a video to show about some of our outcomes because we do collect testimonials, but I'll just share it with you. There was one particular case where a Metro Transit here in Washington, D.C., our subway system has their own police department, and there was a young person that had got into an altercation with a police officer, and ended up pushing the police officer down. He experienced major injuries where he had to have surgery on his shoulder. And the police officer came and said, I don't want to press charges. I want to talk to this young man. I want to find out why he did this and what's going on, because assault on a police officer is a very hefty charge, even for a juvenile. At the conclusion of this conference, that police officer ended up building a relationship with the young person. His wife, who was very upset, he wasn't able to work. She was upset that he got hurt. she was reluctant to come to the conference, but she came to the conference. She ended up beginning to share, and it was healing for everyone. And that's just one of the cases. We have multiple cases where young people will come and their parents will realize that they know each other. And they'll say, oh, man, we know each other. We grew up together. How is it that our children are having this conflict? You know, we're going to work this out. We're going to fix this. Our outcomes that we have seen are amazing. And I'm super excited to be able to be partnered and working with doing restorative justice in this office. I would love to be able to catch young people before they get charged and arrested, because that's a whole trauma in and of itself. But the fact that we are implementing this here at this point, I'm still excited about it, because we are able to catch them from going even deeper. And we're repairing families, we're helping to repair harm, and I'm really excited. I thank Carl Racine and OAG for us being able to really move forward in this work, because all of our work is important. So ideally, we want the community to really embrace the restorative mindset and restorative philosophy so that they can develop better ways to deal with conflict, because as a government and system, you know, we should be the last ones in, right? Communities should be the ones first on the scene and pushing them forward to be able to help and, you know, supply the answers to their own conflict, and really, you know, really support them in that. But the fact that we're able to, as a government agency, help facilitate and be a gap filler for conversation and conflict in communities, in schools, is really, I believe, something that is really helping to really keep these families from experiencing more trauma than what's necessary. I'm grateful. This is a picture of our team. And, you know, we're diverse. We're from all different parts of life. And what we found is that that's ideal. Every person is not the best fit for every case, and we've been able to really be effective in helping different families based on our own backgrounds. And so most people, I believe, on a team is important. My team is extremely important. Our team is extremely important with each other. We talk about every case. We go through it. We comb through it, because every family is important. It's not just a file on our desk. Every family is important, and we take our work very seriously. So I thank you for your time, and I hope that we can spend some time answering any questions.
Great. Thank you so much, Alice. I appreciate that. Okay, so I'm just going to return to our main screen here, and folks, feel free to type any questions you have in, or to do the hand icon if you'd like us to unmute you to ask a question. I have one question right now for you, Alex, and that was, in DC, if restorative justice is completed, is the arrest record expunged?
So currently, at this point, the arrest record is not. The charge is withdrawn, but no, the arrest does stand, unfortunately.
Okay, great. And then, let's see, I want to bring Betsy back as well and ask each of you some questions. First of all, I was interested in what you think are kind of the core principles and philosophies that make up restorative justice.
I'll let you go first, Betsy.
Oh, Betsy, we don't have your audio, I'm afraid.
There, is that better?
There we go.
It's a very complex shift away from punishment and retribution, and I'm not sure that it really could be defined. That's what we struggled with when we were putting together the proposed Supreme Court rule. But I can say that I think a better way to look at it is what rights must be protected, and Alex was noting that as well in order to make sure it really is restorative. So there must be the voluntary participation that Alex talked about with his program. There must be confidentiality. People must feel safe in this conference or circle or whatever you're having. There must be proportionality. There must be neutrality of the mediator. And I think you struggle. I was thinking on the way over, for example, there are peace circles that are that young people are increasingly coming into contact with in the schools that are run by teachers. There are restorative justice proceedings in prisons, for example, to work out disagreements. And I think it gets tricky in those kinds of arenas because you really have an imbalance if you have the convener being someone who is a person in authority. And so it gets tricky, but you certainly have to ensure that there's a way to address underlying harm, but I think also thinking about harm more broadly. And that's one lesson that's coming out of this community court, is that it's a way to educate the system. I heard Alex talking about this too, a way to educate the system about the barriers that are driving people into conflict with the law, and begin to work with the community then to address some of those underlying barriers. It's very complex, but you must have protections in place. You must have trained mediators, trained circle keepers. I do want to say one interesting way that this has been used in Illinois is the ombudsperson for our juvenile prisons used restorative justice circles with young people who were in the prisons to get information, to gather information about what they were concerned about, and make her, that was a key part of her report back to the state on the conditions in the juvenile prisons. So the uses are many and varied. I think it's essential to keep in mind these protections to make sure that what comes out is restorative and not driving people deeper into the system, not causing more harm. Alex, we've gone back and forth on this on discussions ahead of this convening. What do you think?
Well, your question, Melissa, was the principles. What do you think are important principles of restorative justice?
Yeah, that was basically it.
I think that, like Betsy said, describing restorative justice is it's simple, but it's very difficult and challenging because everything around us is punitive, right? Everything from how we, school discipline, family discipline, right? You get in trouble at home, you go to your room, like it's not, and so you have to mind shift. I think the best way I can think to explain it is when you look at restoring a vehicle, right? You have a restoration shop. They do all kinds of cars. And different cars need different things to be restored. Some need interior, some need motor work, some need paint job. But at the end of the day, the car is meant to come out and look like what it originally looked like. And when you look at restorative justice in communities, our goal should be, and the principles, the philosophy should support putting a person, a family, a community back to what they would look like if everything was whole. And that's the goal. And I think that's what we should approach this with. The philosophies of restorative justice is based in community. It's not centered around conflict. We just use it around conflict. But it's about building community. It's about building connectedness to people, bringing the human element back into family, back into how we deal with each other on a regular basis, because that's what community was. This is an indigenous practice that we're using and applying it in a present-day sense. Indigenous practices are all about community. The community did everything together. They celebrated together. They disciplined together. They fought together. They handled everything together. It was about unity. And that's what restorative justice does. It takes us back from our silos and our segregated communities to really connecting us back at the heart so we can repair harm and take on another man's burden, another person's burden. You can't help the community you grew up in. You can't help where you were born. But I can help you now that I see what you need to become and be made whole. Now that I see the broken places in our system, now that I see the broken places in our schools, we can work together to fix those things. And that's what it's about, restoration, putting you back, making you into a position that you can now operate like everyone else, emotionally, mentally, economically.
And Alex, I wonder if I could use one example that the judge has used in this court, and that is early on there was a young person who stopped showing up, and they have very minimal requirements for coming back to court because it is so burdensome, but was supposed to appear and then didn't appear, and the traditional justice system responses, oh, warrant, you know, violation, probation, and she said, we're doing something entirely different here. Go find this young person. Come on, that's what this is about. And it turned out the young person was homeless, and that was the reason for not showing up. There was a good deal more. When we're dealing with the young adult community, the homelessness issue is huge and often a key driver into the justice system. So I think it is, like you said, community, but the court beginning to understand on a more human level what's going on.
I agree.
I want to get into, we have a lot of questions from our audience, and I will tell people that hopefully if we can't get to your question, if our presenters don't mind, I'll send the questions to them and we'll try to answer it that way. I'm going to go with some of the folks who've raised their hands. See if this can work to unmute them. So Daryl King, I've unmuted you if you want to go ahead and ask your questions.
Yes. Do you use surrogate victims if the victim is not available or willing? And how do you identify surrogate victims for Alex?
Can you ask your question one more time? It was a little challenging to hear you.
Do you use surrogate victims if a victim is not available or willing? And how do you identify surrogate victims?
So that's a great question. We have recently begun to talk about that as a part of putting together panels for young people who have done harm and bringing in surrogate victims. So this is how we are very flexible with our victims. So we've had victims who say, you know what, I want to do the restorative justice, I just don't want to be present. Can I write a letter? And can I sit in another room next door? Can my family just show up and kind of express how I feel? And yes, so as far as having a surrogate victim, true to form, I don't think that we have yet to have a surrogate victim that was not directly involved in a case. But if a victim, because the way our process works, everybody has to agree. So the victim of the crime has to say, yes, I want to participate. So typically we wouldn't run into a surrogate victim situation because both parties have to agree. So if the respondent doesn't agree, then we wouldn't do it. If the victim doesn't agree, then we wouldn't do it. So in our form of using this community conferencing, we may not run into that. What we do run into is where a victim wants to change how they want to participate. So I hope that answers your question.
Yes, it did. And another question, Alex.
Melissa?
Yes.
Yes, Betsy?
Just to note that in Northern Ireland, they talked about this issue of, for example, retail theft, and who do you bring in to represent the victim, and having a representative from a merchants association, tapping people like that to come in and represent the victim. The other big lesson for Northern Ireland has been that they always involve people in the conference who are not involved in the offense, because this is a vehicle to teach peace building skills in the community. And I think that's a huge lesson for Northern Ireland. This was part of the Good Friday Agreement after the Troubles there. There's a civil war for healing. And so teaching those peace building skills is key. So
Yeah, just ignore it. Yeah.
Are you still there,
I
Melissa?
think Melissa dropped. I think Melissa dropped off, and I do think we have time for one more question. I see that we have a few that have come in that haven't been answered, and I see that one of them was, how do you get buy-in for restorative justice versus punishment from the referral agency? That it's hard getting the system buy-in because they don't want to give up on this idea of consequences.
You want to go, Betsy? Or you want me to go? Okay. That's accountability is always the one word that consistently comes up, and people across not just in the court systems, but parents, when I was in the school system, they had a hard time wrapping their mind around sitting in a circle and having a conversation is going to hold this person accountable for punching my kid in the face or making them get hurt, causing damage to them. One of the things that we have been practicing is several things. So I guess it's more than one thing. We've been practicing our testimonials. We've been practicing incorporating training for our prosecutors. We've done training for the judges to teach them about restorative justice. But there's nothing that's most important than participating in a circle. Anyone, I believe, that sits in a conference, in a circle, and sees these people who have caused harm to each other, or one person has caused harm to another, and watch the transformation from beginning to end, I would be hard-pressed to see who could not see the power of restorative justice once they've experienced the conference. Those conferences will shift how you feel about humanity, about people who cause harm, because you get to learn not just what they did, but why they did it. You find out from a person that caused harm how far you took the person that you hurt out of their comfort zone. You know, you really get to see the depth of what you've done to someone outside of snatching their purse. You know, I had one case where a young man stole a lady's car and totaled her car. You know, she was on her way to work. She had never been robbed, never been in that type of situation, and now she had to leave that particular job that she was working because she was traumatized, because in her door walked in like 5 or 6 young men who looked like, you know, the guy who robbed her. You know, but this process helped her to come to terms and to get closure in what she experienced. So there's nothing I have seen that holds young people accountable than to have them sit in front of people they care about, sit in front of people that they've hurt, and themselves to communicate not only what they did, but that, you know what, thinking about it, back on it, I'm really sorry I did that. I wasn't thinking, I apologize. What do I need to do to make it right? And so, and also in that opportunity, you find out from young people what they need to change that behavior. So we can provide them supports. And it's really transformative. That's what we've had to do. So the testimonials, incorporating them in our process, being open and transparent to what we do so they don't think it's some kind of mystic thing that we're doing, and really helping them to see the victims. They're always going to talk about the victims. What about the victims? And we have to safeguard people who have been harmed by crime, and it's really good. It's really been helpful for us to do all those things. So that's how we've been able to get prosecutors to really buy in and send us cases, because prosecutors send us cases on their own. So it's not mandatory. So their buy-in has been how we've been able to grow our program out. So.
Thanks, Alex. That's super helpful. I see that we're just at 1, and I want to be respectful of folks' time. I know that folks have busy schedules, and I want to thank you for those last comments, Alex, because it really does speak to the transformative power of restorative justice. Thank you both to Betsy for sharing all the great information about Northern Ireland and about what's happening in Illinois, and to Alex about this really innovative program in DC. I see Melissa's back on with us. I know that some folks have asked for copies of the PowerPoints. I don't know if Alex and Betsy are okay with sharing theirs. We're okay sharing ours. If you want them, you can email info@njjn.org and we can get them out to you. And in about a week, a recording of this webinar will be posted on our YouTube channel, and we'll let you know when that happens. And in the meantime, thank you all for attending and for learning about this, joining with us, and huge thank yous to Betsy and Alex.